Hello, everybody. Today we're going to be doing some notes and we're going to be talking about the Warren Court. So I have a little word box here of some Supreme Court cases we're going to be talking about today and learning about the history of this time period. So the idea of the Supreme Court can come across very boring in most cases. Seeing like this blank versus blank isn't the most visually appealing when you don't know the context of the case already going into it. So today we're going to be talking about a specific time period of the Supreme Court where many changes were made. This is because this time was during the civil rights movement and it was booming and activists were getting changes that needed to be made to make today possible. This time period was called the Warren Court. This time period ranged from October 5th, 1953 to June 23rd, 1969. It also refers to a time when Earl Warren was Chief Justice of the U.S. Supreme Court. A Chief Justice is the presiding or principal judge of a court of justice. Earl Warren was the 14th Chief Justice of the United States. He applied his political abilities to the court and wasn't afraid to confront controversial topics in his court. The Chief Justice effectively ended racial segregation, in U.S. public schools, expanded the constitutional law, for sure, of defendants, ensured equal representation in state legislatures, outlawed state-sponsored prayers in public schools, and paved the way for the legalization of abortion. Now we get into the nitty-gritty of how these decisions and more came about. So basically, in the next few definitions, I'm going to be telling you what the case resulted in and then how it came about. So just to clear any confusion. Starting off with a crazy one that is applied to every day regarding the police is the 1966 Supreme Court case, Arizona versus Miranda. In the original case, the defendant, Ernesto Miranda, was a 24-year-old high school dropout with a police record when he was accused in 1963 of kidnapping, raping, and robbing an 18-year-old woman. Miranda did admit to the claims, but since it was never told him that he had a right to remain silent, they went to court. The decision was in Miranda's favor, 5-4. Now police have to read you your Miranda rights. So it was named after that. To arrest you if they don't have any first-hand proof. Alright, so we're going to be going into the next one. This one is called Jadon versus Wainwright. So this case, the court ruled that every felony defendant was entitled to a lawyer, regardless of his or her ability to pay. Clarence Earl Jadon was charged in Florida State Court with a felony of breaking and entering. When he appeared in court without a lawyer, Jadon requested that the court appoint one for him. According to the Florida state law, however, an attorney may only be appointed to an indigent defendant in capital cases, so the trial court did not appoint one. Jadon represented himself in trial, and he was found guilty and sentenced to 5 years in prison. The decision was made on March 18th, 1963. So 1963, the court ruled that every felony defendant was entitled to a lawyer, lawyer, regardless of his or her ability to pay. So this next one is Engel versus Vital. Engel versus Vital. The court ruled that prayers in public schools violated the constitutional separation of the church and the state. This was brought about when the New York State Board of Regents authorized a short voluntary prayer for recitation at the start of each school day. A group of organizers joined forces challenging the prayer, claiming that it violated the Establishment Clause of the First Amendment. This decision was made on June 25th, 1962, with a 6-1 decision. This next one is the Regents of University of California versus Bakke. In 1978, the Supreme Court ruled that a university's use of racial quotas in its admissions process was unconstitutional, but a school's use of affirmative action to accept more minority applications was constitutional in some circumstances. Racial quotas forced diversity without factoring in actual inclusion, the pathetic attempt to meet numerical goals to appear diverse. This would be considered discrimination, which is ruled unconstitutional from this case. Yeah, I don't think I can spell. You get the point. Affirmative action is an effort by institutions to improve educational and economic opportunities for unrepresented groups and communities. This next court case is Brown versus the Board of Education of Topeka. And I feel like this one is more heard of. This case was a consolidation of cases arising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. relating to segregation of public schools on the basis of race. In each of the cases, African American students had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. They argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs were denied relief in the lower courts based on Plessy v. Ferguson, which is a more common court case as well, which held that racially segregated public facilities were legal so long as the facilities for blacks and whites were equal. The decision was unanimous and made on May 17, 1954. So 1954 was when segregation was outlawed. Okay, so Loving versus Virginia is our next one, and it was a landmark civil rights decision of the U.S. Supreme Court in which the court ruled that laws banning interracial marriage violate the equal protection and due process clauses of the 14th Amendment to the U.S. Constitution. This decision was made on June 12th of 1967. This was brought about when in 1958, two residents of Virginia, Mildred Jeter, a black woman, and Richard Loving, a white man, were married in the District of Columbia. The Lovings returned to Virginia shortly thereafter. The couple was then charged with violating the Stuarts' anti-miscegenation statute, which banned interracial marriages. The Lovings were found guilty and sentenced to a year in jail. So after this, they brought it up to higher courts, and this is how this decision came about. All right, so our next one is Griswold versus Connecticut. And this was a landmark decision of the U.S. Supreme Court in which the court ruled that the Constitution of the United States protects the liberty of married couples to buy and use contraceptives without government restriction. This decision was made on June 7th of 1965, with the vote being 7-2 decision in favor of Griswold. In 1874 or 70, I'm going to go with 1879, the Connecticut passed a law that banned the use of any drug, medical device, or any other instruments furthering contraception. A gynecologist at the Yale School of Medicine, C. Lee Buxton, opened a birth control clinic in New Haven in conjunction with Estelle Griswold, who was the head of Planned Parenthood in Connecticut. They were arrested and convicted of violating the law, which what then leads to the case being brought to the higher courts. So another case that is highly talked about upon topic even up to the present day with the case regarding abortion was the Roe versus Wade case. This case was a landmark decision of the U.S. Supreme Court in which the court ruled that the Constitution of the United States protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. This was brought about when in 1970 Jane Roe, which is a fictional name used in court documents to protect a plaintiff's identity, filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she resided, challenging a Texas law making abortion illegal. Except by a doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy, protected by the First, Fourth, Fifth, Ninth, and 14th Amendments. The decision was made on January 22nd, 1973, with votes favoring Roe in a 7-2 decision. Although this didn't take place in the time period of the Warren courts, this argument would probably not have been brought up this early without it.